Ready? Start. The order impugned in the present appeal was passed by the learned single judge on 14th May 1996. The plaintiffs were exempted from paying the balance amount of court fee subject, however, to the direction that in the event of their success in the suit, they would pay the requisite court fee from the decretal amount. The learned counsel for the appellant has challenged the aforesaid order on the ground that the same is contrary to the law. In support of this submission, the learned counsel has invited our attention to the various relevant provisions contained in the Code of Civil Procedure as also in the Court Fees Act. It was submitted that a receipt of rupees 1 lakh from the appellant was not denied by the plaintiffs. The learned counsel for the plaintiffs did not dispute this assertion. In the light of this admission on the part of the plaintiffs, it was urged that the plaintiffs could not plead lack of means to pay the requisite court fee as a ground for seeking exemption to pay the requisite court fee. Secondly, it was contended that the court had no power to grant exemption from payment of court fee. The only other course which could be followed by the plaintiff was to approach the court as indigent persons under Order 23 Code of Civil Procedure. The said provision in the code was specifically meant to safeguard the interests of persons who do not have sufficient means to pay the prescribed court fee on the plaintiff. Order 33 envisages an inquiry about the financial condition of the applicant so as to find out whether he/she was sufficient means to pay the prescribed court fee. The learned counsel for the appellants submitted that the plaintiffs were conscious of the fact that in the event of an inquiry into their means to pay the prescribed court fee, they would be faced with the fact about receipt of rupees 1 lakh from the defendant on account of the fatal accident involving their son. The receipt of this amount would militate against their assertion of lack of means to pay the prescribed court fee. For this reason, the plaintiffs did not choose to take recourse to Order 33 of the Code of Civil Procedure according to the learned counsel for the appellant. It was also contended on behalf of the appellant that under Order 7, Rule 11, Code of Civil Procedure, an insufficiently stamped plaint was liable to be rejected. Although the said provision envisages grant of further time to a plaintiff to make up the deficiency in court fee, yet the proviso contained in Rule 11 puts a heavy burden on the plaintiff for making out a case for extension of time. The court has to be satisfied by the plaintiff that he was prevented by any cause of exceptional nature before the extension of time can be granted, and the court has to record reasons for granting exemption. Thus, according to the appellant, there is to power with the court to grant exemption from payment of court fee. The only power is to extend time in making up deficiency in court fee, and that power also has to be exercised not in routine but in cases of exceptional nature. On the other hand, the learned counsel for the respondents plaintiffs relied on section 94E and section 149 of the CPC to urge that the court had the power to grant exemption in such matters, and therefore the discretion was validly exercised in favor of the plaintiffs by the court while passing the order in appeal. Stop.